All right, welcome, ladies. Glad you decided to take your evening to come here and hear this. My name is Solomon Gibson III, and with presentations like this, it's always kind of difficult to decide how to start them. You want your audience gripped from the first word, saying, "Ooh, this is going to be exciting." And so, well, I've settled on a couple of disclaimers. While the fine organization, the Ethical Humanist Society of the Triangle, is sponsoring my talk, everything in it is mine. So if there's anything that upsets you or concerns you, blame me. While legal may be in the title, I am not a lawyer, nor am I putting myself off as one. However, I have consulted with a number of people smarter than I am about this material, including several lawyers who have said that this strategy and solution is viable. Now, typically when one talks about this issue, there can be a lot of high emotion. And it can tend to be simplistically designated as pro-abortion. That is not the case with this material. What this is about is equality and fairness and maximizing of choices, something we can all identify with, from going and doing our shopping, buying clothes, to buying a car or a house. We appreciate having choices and options, and we kind of balk at anyone that says we cannot have those choices. And that's what this is all about, the maximization of choices and options for what is oftentimes a complex situation. Now, how did I get here? Several years ago, I was at a seminar on abortion and reproductive rights. Specifically, the person there was teaching us how to call into conservative radio talk shows and make our opinions and points within the couple of minutes that we would have. While he was doing that and going through his paces, an idea occurred to me, a line of logical thinking and approach that would make my points irrefutable. And so when there was an opportunity for role playing with the trainer in the position of the conservative radio host, I decided to try it out. And it worked. After a short exchange, he could not refute whatever my point, the point that I was making. Now, at the time, I could see that there were some holes in the logic, some weaknesses. And since I'm the kind of person that likes to solve a problem once and for all, so I can put it aside and move on to the next one, I put this up on the shelf for a time, realizing that over a period, I would pick up information at various times that would help shore up some of the weaknesses that I saw in this logic. And that's just what happened. Conversation here, some information there, and over a period of time, I had shored up all the weaknesses that I could find. It took a little more fine tuning. And at that point in time, I realized that for this strategy and solution to be effective, really effective, it had to be shared, put out there. And so here I am, and here you are. Now, to get us all on the same page, a quick, brief history of the abortion issue in this country. Now, the recent Dobbs decision and several conservative talking points would have you believe that anti-abortion sentiment and restricting abortions was the norm for this country, the status quo throughout its history. Well, the issue has existed for the last 165 years. And you may hear some say that the statistic, 1865, 75% of the states were anti-abortion. Abortion was illegal in 75% of the states. Now, this stat is true. However, like such information, you can cherry pick so that it fits your point of view. It could just as easily have been said that in 1885, abortion was illegal or heavily restricted in 100% of the states and be just as accurate. However, if you go back to 1855, it's an entirely different picture. From the beginning of the country, whether you start in 1619, 1776, or 1789 with the ratification of the Constitution, abortion was available. It didn't cause much of a ripple. It was accessible. Even the church had no problems with women having abortions until the time of fetal movement, which of course was up to the woman. It wouldn't be until the mid-1850s that the American Medical Association would join with white male nationalists to push to have abortion illegal in this country. The AMA did it for reasons of controlling medical practices. They wanted to limit competition from homeopaths and midwives. And white male nationalists wanted to bolster white supremacy through birth rates and pushing back against growing immigration. Morality had very little to do with it, other than as a selling point for the public. And the strategy was successful. By 1880, abortion was illegal throughout the country. And that became the status quo until 1973, with Roe v. Wade, of course. Supreme Court rules that abortion is a constitutional right. Kind of, sort of. There were restrictions. And I'm going to take a little side step here and say that we've been listening to some leadership say that they want to codify Roe v. Wade into federal law. This frustrates me no end. That should not happen. And I'll explain why in just a few minutes. But with the Roe ruling, it too did not cause much of a ripple until what happened was conservatives and Republicans saw an opportunity to galvanize and consolidate the evangelical vote by making the ruling a moral issue. And just like in the 1850s, the strategy was successful through this present day. Because what we have seen from the very beginning was that the procedure for terminating a pregnancy was separated off from the main hospitals into clinics of their own, making them more readily available for protests and overregulation. And throughout the past 50 years, we have seen access to abortion procedures experience death by 1,000 cuts. Right on up to the Dobbs decision, where the court, in essence, reversed Roe v. Wade by tossing the right back to the states. Now, since the Dobbs decision, we have seen all of the outrage, the shock, the fear, the sadness. We have listened to pundits relay horror stories about the past, the present, predictions of the future, lawyers and people running around trying to figure out what they're going to do next or how to address this issue. It has all kind of boiled down amidst all of this into two strategies. One, expand the Supreme Court. Now, despite what some have said, this is not a radical idea. The Supreme Court's numbers have been changed or been attempts to be changed over half a dozen times in its history. The most recent, Franklin Delano Roosevelt in 1937. However, the current Congress and the president have shoved that strategy off to the side, leaving us with one strategy and solution, or so we are told. And that is expanding the party in Congress who has said they want to do something about this issue. And there's only one party. The idea, vote, get out and vote, vote. I'm sure you've all been exposed to this. In fact, you probably received emails to tell you to get your friends out to vote. All of the things are pushed to vote. The belief is that this is the one idea, the one solution to this issue. That is not true. It is the most accessible, and it can galvanize all of the current energy, but it is not even the most effective or the most comprehensive. Best case scenario with this strategy. The Democratic Party maintains the House and gets their 54 plus members in the Senate. The House crafts its compromise bill and passes it. The Senate crafts its compromise bill, perhaps in conjunction with the House, passes it. The two bills are reconciled. They move to the president's desk. The president signs it into law. Conservative states promptly challenge it in the courts. It moves through the federal court system and winds up with the Supreme Court, which will do who knows what. Now, there are only three basic things it can do, but who knows? While it is moving through the federal systems, however, the country goes into a sort of holding pattern as far as this issue goes. The states with the draconian abortion ban laws can't quite put them into play, and so no arrests of patients or doctors. They can't really prevent abortion medication from crossing the state borders. At the same time, the availability of abortion access won't expand very much as well, as we're all in a sort of status quo until this law is determined through the court systems. That's the best case scenario in the current political climate. Now, I don't say this because I'm against the strategy of voting. I'm an advocate of voting. By all means, vote myself. In fact, early voting starts on Thursday. So go out and do that. Heaven knows there are plenty of things that need to be done. And by the one party that has tried to do them. You know, climate change, healthcare, immigration, infrastructure, pick your issue. So vote, go out and vote. What I am saying is that if your issue is abortion and reproductive rights, then this strategy may not give you the satisfaction you are looking for. So don't be disappointed. However, there is another strategy and solution. No one is talking about this. As far as I can tell, if anyone knows about it, it is not making its way into the public arena. This strategy and solution needs no new laws, no new amendments, no new policies. You don't have to flip Congress, doesn't matter who is in the presidential office. No new precedents or precedents have to be changed. In fact, it does not interfere with any ongoing strategies. And when I describe it, it almost feels like a con. All that is required for this strategy and this solution to work is a fair and consistent application of current laws and interpretation of constitutional rights. And the very foundation of this strategy and solution is one thing and one thing only: complete and total bodily autonomy. In fact, that should be the goal of any legislation that comes out of Congress. Complete and total bodily autonomy, no compromise. Now, I know that some moderates and progressives, when you say no compromise, think of extremes and that it's non-productive, that there must be some reasonable middle ground that we can all agree with. That is not true. And there's a number of reasons for that. Any compromise will be neither fair nor equal. For all intents and purposes, men have complete and total bodily autonomy. Whatever goes on with us is between doctor and patient. The state's only interest in getting involved tends to be one of safety or legality of the treatment that the doctor is offering. They're making no preemptive laws that get in the way of our access to whatever treatment is out there for whatever's going on with us. Shouldn't women have the same option? Any compromise is stating that women cannot be trusted with this life and death decision without government oversight, that they will be irresponsible, and that is insulting. Now, I don't believe that men are more responsible with life and death decision-making than women are. And we have an entire military industrial complex that demonstrates the irresponsibility of men on this point. Another reason there can be no compromise is because we have already had one, and it has failed. Roe v. Wade was the compromise. And anyone that tells you that Roe was some kind of radical decision and we're only looking for a more reasonable middle is being disingenuous. Roe v. Wade gave us a trimester guideline system based on viability. What it was is that for the first 13 weeks, the woman had complete and total bodily autonomy in consultation with her doctor. The last 13 weeks, the state could pretty much ban abortion, except in the cases of rape, incest, and maternal health. The middle 13 weeks was a kind of mix. States could intervene, but usually for reasons of maternal health. What that boils down to technically is that women had complete decision-making in 1/3 of her pregnancy, and states could intervene to varying degrees in 2/3. And this 1-to-2 ratio was not enough. Now, I'm going to explain, as I promised, why I don't think Roe v. Wade should be codified into federal law. Not only, as I said, are compromises essentially unfair, or that Roe allows a level of egregious intervention into pregnancies, but in codifying this law, you will be formally establishing a second-class status for women. And that should not happen. So I always scream at my screen, no, whenever the leadership says, we need to codify this into law. No. Something better needs to come out of this. Now, what we have also seen in that is that the compromise failed. We have seen it eroded over the last 50 years to where we are right now. Now, the last thing I will say as to why there can be no compromise is because the faction that is against abortion and reproductive rights cannot do it. They simply cannot on this issue. Any pro-life person, organization that says they are looking for a reasonable middle is not being honest with you and or themselves. Because they cannot compromise, and it's not for any extreme reason or any wild thing that can't be understood. Of course we can understand it. Despite what people say about the left or progressives needing to understand conservatives more, we can understand this perfectly. I mean, if you have empathy and compassion at all, we know what it's like to have a baby in our arm, to look at these cute little creatures smiling at us, helpless and needy. And we know the outrage that we feel with any situation that may do them harm. But most of us are able to compartmentalize and differentiate the developmental stage from the little baby we're holding in our arm. However, if you cannot do that, if you cannot make that differentiation, if the emotions you feel when holding that baby stretch back to conception, then of course you cannot compromise, not for 20 weeks, not for 13 weeks, not for 6, not for a single week. You cannot do it. Perfectly understandable. So what does that leave for the pro-choice faction to do if compromise is off the table? And it is. Well, basically 2 things. 1, capitulate, throw up your arms, say, I'm tired of beating my head against this brick wall. I'm going to devote my time and energy to comprehensive sex education and the availability of birth control and contraception. And for those people that fall between the cracks, hopefully there's something there that will help them out. The second thing you can do is exactly what your opposition is doing. If you believe that a woman has a right to make decisions in this complicated world about what goes on with her body, if you believe she should be able to navigate with the most options that she can this complicated situation, then you have got to dig your heels in and fight. And there can be no compromise because your opposition won't let you. So if the goal is complete and total bodily autonomy, no compromise, what's the solution to get to that goal? And that can be summed up into a single sentence. Our courts need to be made to establish the specific constitutional legal status of a fetus. Once again, our courts need to be made to establish the specific constitutional legal status of a fetus, to legally determine whether it is a person or not, because this goes directly to constitutional rights. If you're a person, you have them. If you're not, you don't. Our courts and institutions have been getting away with, have been allowed to get away with playing in a fuzzy, indistinct middle because of how we feel about pregnancies and babies. They've taken advantage of our emotions and attitudes concerning Christian morality, allowed to play fast and loose with the law. And that needs to cease. So if the courts have to make this differentiation, person or not, what does that mean? Well, I'm going to start off by talking about what is the current legal status of a fetus. And that is, it's not a person. At no point in the history of this country has the fetus ever been given personhood. Not in any state. No institution, secular institution in this country, has ever treated the fetus as a person. No tax laws, census, birth certificates, driver's license, pick your institution, they all begin at live birth. The Supreme Court in 1973, the Roe decision, stated in that decision that they were not establishing personhood in this ruling. And of course, what that means is they look back on the entire legal history of the country. They weren't taking personhood away from it. They saw that fetuses didn't have it, and they wanted it clear that they weren't establishing it. And let's be clear that the term is person or people, not human or human beings, as some states will try to work around to. In law, human is not a euphemism or substitute for the term person. And this, of course, was also kind of established by the framers, that three-fifths compromise was three-fifths of a person, not three-fifths of a human. And you had to be a whole person because that three-fifths got no constitutional rights. And if you want to add to this, the current conservative court just ruled not 2 weeks ago in a Rhode Island case, given the opportunity to establish fetal rights, did not do it. So legally, there is no doubt the fetus is not a person and it doesn't have rights under the Constitution. So what does this mean? Well, first of all, it means that if you're ever in a conversation and someone says, well, you're talking about the women's rights, what about the fetus's rights? They don't have any. The only right you can talk about, if you talk about rights at all, is the woman's. What this also means is that legally, pregnancy is a medical condition. It can't be anything else. And the state should have no more interest in this medical condition than it has in any other medical condition. In fact, its obligation is to support the group with rights, not the group without them. So the woman is allowed, in consultation with a doctor, to access safe, approved legal treatment for her medical condition. She gets to decide what happens with her pregnancy under current law. Now, I'm going to take some time here to talk about the Dobbs decision and why it is so dangerous. And I'm not talking about that Clarence Thomas statement about overturning Obergefell with same-sex marriage, or going back to Brown v. Board, or messing with all the little decisions that are made that kind of sort of level the playing field socially. Those are different cases, and they're going to take up other time. I'm talking about what the Dobbs decision does that is so dangerous right now. Because what it has potentially done, well, what it has actually done, is it has said that states can take a group with no constitutional rights and give them some. that they can give special rights that are superior, that would allow this group to use the bodies of a second group that has constitutional rights for as long as it needs to, for its own benefit. This is in complete violation of the 14th Amendment, and the reason given that the state may have for doing it, a potential violation of the 13th Amendment. Not only that, on top of all of this, that this special superior rights that they are bestowing on this group go away automatically. They come and go with no benefit of legislation. What that means is that only one group gets to enjoy this superior right that the state has given it, which is, once again, a complete violation of the 14th Amendment. Given that, what that means is that the state, why would that special right have to be temporary? It could bestow this right on any group that it chooses. White people are superior to Black people and can use their bodies as long as they needed to for their own benefit. Men are superior, can have a superior right to women and can use their bodies for as long as they need to. Could give your animals, your livestock, your pets. This is potentially one of the things that Dobbs has given to the states, a devastating power. And no one is talking about it because everyone is diverted on to Clarence Thomas and what he has said that isn't happening yet. So, in synopsizing this first segment here, if the fetus is not legally a person, and it's not, then pregnancy is a medical condition. The state should have no more interest in this medical condition than any other medical condition, and the woman, in consultation with a doctor, should have access to safe, approved legal treatment for her condition. In short, if the fetus is not a person, the woman gets choice. And now, at this point, I'm going to ask for questions.
Because these are some super logical arguments, so I get it, but how would think, oh, now how did you put that? I'm serious.
I understand. I've also got a little outline too.
Oh, okay. Oh, great. Okay.
Not too many handouts because the what I'm describing here isn't anywhere. It doesn't exist anywhere because it's pieces from different things that have been put together for what seems to be a logical approach. And so I have no websites, no books or articles or anything like that. Yeah. And so I went to pause a moment and see if anyone has any questions because I know it's just like that.
So you saying the piece about full personal autonomy makes me think of end-of-life decisions and physician-assisted suicide and euthanasia. So I wonder if you've looked at any of that as borrowing from those arguments, and why hasn't this argument been made? It just seems like the two are just so naturally, would naturally go together.
I didn't look at euthanasia because I was focused specifically on this. My decisions about euthanasia is they're simpler in many ways, and because this particular issue goes to other things, and it's bigger because we're talking about everyone, not just those people that are wanting to end their life. I'm a big fan of personal decision making myself, and so my things about that are actually simpler. I spent time on this because it seemed more complicated. It worked on different things, not just my thinking or everybody's thinking. It also worked on my emotions as well, because I was locked into a certain level of emotional feeling about babies and pregnancies and the specialness of all of that. That kind of prevented me from thinking beyond what was offered. And so my thought tends to be is that if this strategy works, and it actually is quite logical, as you see, because I've got a couple of parts, is that it will address a number of things, not just solving this issue. And not only that, I kind of got excited about looking at this and saying, wait a minute, this is actually the solution. This solves this issue once and for all if they do it. And like I said, I like to solve a problem so I can move on to the next one because there's so many. And I saw this and I had the same question you did, which we can talk about afterwards. Any other questions? Look like you're thinking.
Well, it's a lot to chew on, and and as she said, all of this seems very logical, and I know that when I get home, I'm going to also think about the way you've laid it out and the logic and the way it lines up, and I'm going to fluff up the whole thing. And it needs to be laid out in the same way because it is a logical way to approach it.
And that's just the first third. Segment 2, of course, that I had an issue with when I first thought of this,
is of course what conservatives will say, and what is generally always talked about, is that, okay, it's not a person. Well, make it a person. Legally established personhood for the fetus. And so what happens if the state does that or the courts rule that? And it's kind of amusing how progressives tend to have shied away from this. It's one of the fears, because the idea here is that if the fetus is given personhood, game over, done deal. It has all the rights and protections that we all have, end of story. There's nothing we can do from that point. This is not true. That's only the first half, actually. We don't tend to think about the second half of that. Yes, if the fetus is given personhood, it gets all the constitutional rights and protections that we all have, but it also gets the limitations to those rights that we all have. One of the most important being that one person's rights cannot infringe or impede another person's rights. My rights stop where your rights begin, and vice versa. And it doesn't matter what I may need. I cannot infringe upon your rights for any reason whatsoever under current law. If I am laying in the streets and I need blood and I'm dying, they can't strap you to a table if they find out that we are a match and take a pint of your blood without your permission. They can't even test to see if you're a match without your permission. And so the woman is entitled to say that this fetal person is infringing upon her rights. And it's only going to get worse as time goes on. So I'd like it removed. And under current law, her concerns have to be addressed. In consultation with her doctor, she is allowed to access safe, approved legal treatment to have this person removed and no longer infringe upon her rights. Now, what if the state doesn't do anything about it? Ignores what is actually precedent. There is plenty of precedent for interfering with another person's right. Well, if the state just does it, then it's reneging on its obligation, for one, and I can only imagine the number of lawsuits that could come out of that. But say the court side with the state. Then what the court has done is given the states devastating powers again by saying, even more so, that this person can now infringe upon the rights of this person. And this is in total violation of the 14th Amendment and absolutely a violation of the 13th Amendment, because the state is now saying that this person is enslaved to this person until it's ready to go. And so if we take that, then if one person now is superior to another person based on their need, then that has to be true for all of us. You can be strapped to a table and have your blood taken to save my life without your permission. That rich person that needs your kidney, well, he's important. In fact, any part of your body that doesn't kill you can be taken and used by someone else because the state can now do that. If you take this even further, and the state wants to mitigate its 14th Amendment violation, then the woman would have the right to say, why am I the only one responsible here? Why are my rights the only ones that are less? There was somebody else involved in this. What about that person? And the state would be able to take the person she pointed to and insist on a paternity test against his will. And if he is found to be the other person involved, well, the state could obligate him to 9 months of paternal responsibility, health care, shelter, food. However, that's all kind of fanciful. And for the state to be able to do that, we're of course going back to the first segment with superior powers for certain groups that the state would be able to do. The other question that is always put out there to kind of mess with our emotions is that, well, the fetus can't survive if you remove it. You remove that person, it dies. That's murder. Well, not really. First, let's bear in mind that under the law, we are not obligated to save the life of another person. I know that sounds bad, but we are not. And we are certainly not obligated to sacrifice any of our rights or our bodies to save another person. And so the responsibility for preserving that life is not the woman's. If anything, it's the state's. If it's that important, then the state has to figure out how to make it survive. But getting more to the murder question is that it's not necessarily that. What can be seen under the law is that this person is infringing upon the woman's rights. Her inalienable rights to life, liberty, pursuit of happiness, certainly her right to privacy. This fetal person may be a threat to health, even to life, which means that the removal of this intruder is self-defense, not murder. And if it is removed at the time of viability, that's withdrawal of assistance, which is also not murder. So that is in the law, and that is a legal definition of what can be done. It is not necessarily murder to remove an intruder from your most personal space. So to synopsize this section, if the fetus is a person, then its rights cannot infringe upon the woman's rights. She is entitled to have this person removed from her most personal space. And law enforcement and legal institutions have to address her concerns. She is able to see a doctor in consultation with that doctor, have this person removed. She gets to decide what happens with her pregnancy. In short, if the fetus is a person, the woman gets choice. End of part 2. Questions?
Are you on one side of the fence and whether the fetus is a person or not?
Me, I'm not. And it's not necessarily.
Honestly, there are 3 answers to that, and they're all amounts to the same thing. I am not on the fence, but it's not up to me. Honestly, this is what the law says. And that will always be my answer to most questions like that. It's not me, it's the law. And that will be absolutely truthful. But if there are no questions, then as you can see, it doesn't matter what the legal status of the fetus is. If it's a person, the woman gets to choose. If it's not a person, the woman gets to choose. The only reason the woman doesn't get to choose is because the courts have been playing fast and loose in that middle. So, if this is the solution, then what is the strategy that gets to this solution? Well, in the 165
years that this issue has existed in this country, there has only been one type of strategy that has ever done anything about this issue. Only one. And it hasn't been laws, policies, or amendments from Congress. There's been no declaration or executive order from the president. The only type of strategy that has ever done something about this issue has been a legal strategy. And that, of course, was Roe v. Wade. And that's exactly what this strategy is, a legal one. What it is a constitutional challenge to the state's ability to deny access to safe, approved legal treatment for a group's medical condition. Once again, a constitutional challenge to the state's ability to deny access of safe, approved legal treatment for a group's medical condition. And it goes somewhat like this. Person or a member, a group or a member from that group says that my 14th Amendment rights are being violated against discrimination, are being violated by the state's ban on abortions because it is denying me access to safe, approved legal treatment for my unique medical condition. And that's what the state is doing. It is discriminating against one single group of people. Because they're not restricting safe, approved legal treatment for any other group. In fact, they're not restricting any other safe, approved legal treatment, just this one. And that is the very definition of discrimination. It's not happening to anybody else, but this one group, women. And so the constitutional argument is that is a violation of discrimination. That is a violation of the 14th Amendment against discrimination. Now, if the courts take that up, and they should, because this is a constitutional challenge, and it can be explained, then the states have to come to the court and explain why it can discriminate against one group of people like this. And they've only got one reason. Given the group and given the procedure, there is only one reason the state can give. And that is the reason that the Supreme Court gave them. A recognized interest in prenatal life. It says it in Roe, and a recent conservative court they used it again. They used the word legitimate, but it amounted to the same thing. A recognized interest, a state's recognized interest in prenatal life. Now, once the state gives that, then the next question that should be posed to the court is, well, does that prenatal life have rights that allows the state to discriminate against this entire group of people definitively and consistently? And the court would have to answer that question. And once the court answers that question, then the solution kicks in, because it doesn't matter at that point. If the life has rights, the court has to state what those are, but that means that it clashes with the woman's rights and she gets to choose. If the prenatal life doesn't have any rights, then why is the state interfering at all? The woman gets to choose. So once the court has to answer that question, it doesn't matter which way they answer it. I love that look. Hold on. So the solution kicks in. And pretty much in the story. Now, what tends to happen is once the solution kicks in, the question becomes is what if the state does have the right to deny safe, approved legal treatment for a group? Because that's what they're doing to women. If the state has that ability, once more it has devastating power, which is also what Dobbs has done. And what that means is that the state now has the ability to deny safe, approved legal treatment for Tay-Sachs for Jewish people, sickle cell, treatment for sickle cell for Black people, HIV medication, which they're doing, transgender medication, which they're also doing. They have the power to be able to deny safe, approved legal treatment for any of us. If they can find the group, geriatric medication, well, no. And that's if the courts give the state that power. Now, several questions come up. One of them is why this strategy? Why this roundabout way to getting to the goal? Why not just go straight for fetal rights rather than this access? And the reason for that is that I don't know that there's a way to do that. Because that's not what the courts in the states technically are doing. That's kind of the end result, but that's not really what they're doing. If you look at the courts, they're not saying we're giving the fetuses rights. The court has said, well, we're telling the states that they have an interest. And the states will say, well, we're not giving the fetuses rights, really, if they're pushed to it. And so I don't know that there's any real way to get to there from here if they're not doing it. However, even if you could figure out how to do that, what would wind up happening if you go directly to fetal rights is that the states would work around that by saying, that's not what we're doing. We are regulating a medical procedure. And consequently, you have to deal with that first case and then go back, hopefully, and get that, the states, and then work your way back around, maybe, kind of, sort of, if you could. So what this strategy does is cuts the state off at the pass. It goes where they're going to run to. And what that means is that the solution doesn't lead to the strategy, but the strategy will always lead back, can always lead back to the solution. But where the states will hide is in their ability to regulate procedures. And this brings up the question, and the statement that has been tossed out there is that there is no constitutional right to an abortion. That's what I've heard some people say. And the question is there a constitutional right to abortion? Well, if you're going to take that attitude, then there's no constitutional right to a vasectomy. There's no constitutional right to heart surgery. There's no constitutional right to any medical service. It's not there. But no one is going to sit and say that we don't expect to have access to medical treatment if it's available for us if we should need it or even want it. Why? Life, liberty, pursuit of happiness, 14th Amendment access, then one of those enumerated rights, just like the right to privacy. We feel like we should have access to medical care. And we are not wrong about that. So is the right to an abortion, is a constitutional right to an abortion? Well, there's as much a constitutional right to an abortion, the procedure for terminating a pregnancy, as any other procedure, because this procedure has also been used to save lives. And so the question is disingenuous, because that question isn't asked of any other medical procedure except this one. Nobody says, well, there's no constitutional right to brain surgery. Now, the last thing I'm going to talk about in this segment is what the courts have done with a single statement. And that is recognize interest in prenatal life. I recently started to think about that. I always knew it was problematic in Roe, but recently with a recent ruling, I thought about it a little bit more. And I came to the conclusion is that it doesn't really make any legal sense. It is a statement that once again plays on our feelings about babies and pregnancy. But as a matter of law, it is vague. And especially with the elimination of the trimester guidelines, it can be broadly interpreted by whatever state government decides that it is. The word interest doesn't really say anything other than that the states are allowed to do something. And recognized, the question was by what? Where in the law, in the Constitution, is there a recognized interest for the state in prenatal life? That's very specific. And so I'm of the opinion that the court made it up because it was a way to get a compromise in Roe v. Wade. By saying that the state had a recognized interest in prenatal life, why doesn't the state have an interest in your kidney or your liver? Is that it allowed the states a certain level of power that the courts could give it that would satisfy certain factions of society. That it doesn't really exist as anything, that it's something they figured out. Because I can't find out how that means anything. And so as a part of this strategy is to be able to, as I said before, to challenge that statement, to ask how the state does have that right. I don't know if there's been any legal challenge to it, because as I said, I'm not a lawyer, and so that's above my pay grade. But that was my question. I haven't heard that they have done that. I hear that's always the final thing that a court does, and so they're able to toss out whatever challenge that's Planned Parenthood adds against the state, and end of story. So, to synopsize segment 3, the strategy is to constitutionally challenge the state's ability to deny access of safe, approved legal treatment for a group's medical condition. It is a challenge to the 14th Amendment right against discrimination that the state is violating by having an abortion ban. And this strategy can work in any state. It doesn't matter. As long as there is any restriction on the procedure for terminating a pregnancy, this strategy can be implemented, whether it's Texas or California, Alabama or New York. Any restrictions, this strategy can be used for that. So, questions? Yay!
Well, number one, I think the states, North Carolina, has denied medical care by the legislature failing to expand Medicaid, in my opinion. That really is a denial of medical care for many people, almost 500,000 people in North Carolina. Number two, the other thing I wanted to just ask you about is, are we talking about the possibility of what is going to, a constitutional challenge? Are we looking at a class action lawsuit?
It can go either way. The idea, and of course you're right, because to be able to deny safe approved legal treatment, it is something that was done in the past already. Black people could not access white hospitals. And so we're not talking about a slippery slope. Like I said, I'm not a lawyer. How this strategy would be implemented, I can see it either through an individual of the particular group or the group itself, because it can be done nationwide in every single state. that has abortion restrictions. Every single one of them. And so whether or not we would be looking at just North Carolina or the entire country, I don't have the slightest idea. Part of my motivation is to get this out there, and if it makes sense to people, that they take it and run with it. The idea being is that people like myself and ourselves, families or people that get involved, we eventually contact their legislatures and say, why aren't we talking about this? This makes sense to me. So why is this not on the agenda? Why are we talking about Roe v. Wade when actually right now we could be doing this? Because this requires nothing else. It doesn't require any changes in the law. They all exist right now. It's just that nobody is using them in this way.
Do you think the passage of a Equal Rights Amendment, just like the one we tried for in the 70s, or, it's still alive, I mean, it's still out there rumbling. Do you think that would have much of an impact with regard to what you've been talking about? Would it short up?
I've thought about that because the question always kind of comes up. And my conclusion with that is in looking at history, what I have seen is that any constitutional amendment or policy that has been aimed at satisfying an issue to a single group winds up getting worked around. Anyone with the wherewithal or institution who wants to do it works around it. Every one of the Reconstruction amendments was worked around. Every single one of them. And we're still talking about voting rights. That was at the very beginning. And we're on our 4th or 5th incarnation of saying everyone should get the right to vote who wants to. And so I suppose the amendment can be worded in such a way, but I don't have a lot of confidence in it because of what our country has proven it can do. And not only that, it could take a really long time. We're looking at 50 years now, and lawsuits because they're still arguing over who's eligible. Now, I'm not saying don't do it. Like I said, the strategy I've given here and the solution I'm giving here doesn't interfere with any of that. It doesn't interfere with voting. It doesn't interfere with an amendment. It doesn't really interfere with any federal policies or laws that may be crafted. Because everything I've said here now currently exists in the law. Yeah, go ahead.
So you say this primarily requires a legal strategy that is through the courts as opposed to through the legislators. So have you approached the ACLU, for example, about this idea?
I have not, and there's been a reason I haven't talked to any more lawyers or tried to get this to my congressmen or all those folks. One, it's a difficult thing to do. As an ordinary person, I have no sway. And so trying to get to my legislature and saying, I've got an idea, and convincing them has been kind of fruitless, and I kind of bailed on that fairly early. I also did that with lawyers. I was talking to several lawyers and explained this to them and having them go, that sounds reasonable. And then you don't hear anything after that. I eventually came to the conclusion, the only thing I had heard was that the reason we're not doing it is because people aren't behind it. Well, people aren't behind it because,
I don't know about it.
yeah, they don't know about it. And so what dawned on me, that as an ordinary person, no credentials or, I don't have any skills I can sell that says I'm an abortion rights expert. I simply decided to talk to people. And if it makes sense to people, then them talking to other people, talking to their legislatures. The legislatures start hearing phone calls and getting this question the same way they're getting questions to vote for Roe or these these other things, then they have to really start thinking about what's going on. If the media gets a hold of it, they have to start asking these questions. And that becomes my effect on these things. That if it gets out there and people start asking these questions, then it can become a strategy. Because lawyers then will start thinking about taking it up and saying, you know what, this may work. And that's what happens.